morning, everybody. My name is Rebecca Stevens, and I'm a senior associate in the employment group at Farrell, LeBron and Martel. And I'm excited to be chatting with you guys today about all the employment updates that are going on right now. Obviously, there are a lot of issues facing employers right now, both with respect to the COVID-19 pandemic, returning employees to work, as well as just some of the general employment law issues that California employers are constantly facing. So we've got a lot of content to cover, but as Margaret said, please, if you have any questions as the presentation goes on, please feel free to share those questions in the chat and we'll save some time at the end to get to them. So some of the topics that we'll be covering today, obviously COVID-19 is a big portion of everything that's going on right now. So that's going to be a big component of today's presentation. As employers start to return employees to work, as more and more businesses are allowed to reopen, we'll be covering some of the safety considerations and employment law issues related to that. For those employers who still have employees working remotely, we'll just do a brief overview of some of the issues relating to those teleworking employees and how to ensure that you're complying with all the requirements there. Most employers probably were dealing with furloughs, layoffs, and reductions in hours a little while ago at the beginning of the pandemic, but if anyone's still dealing with those types of issues, we'll cover some of those topics as well. As we return employees safely to the workplace, there are a lot of employee privacy and medical considerations that you should keep in mind, so we'll cover those. EEO obligations remain in full effect even though we're in a pandemic, so we'll cover some of the new guidance that's come out there around how to comply with those obligations now. And then finally, dealing with employee time off options, we'll cover some issues that have come up with respect to that. So first, the topic that's on most people's minds right now is, safely returning employees to work, especially after many have been working from home or maybe some have been out of work. We'll cover the new guidance that you need to keep in mind. So there are a lot of different sources of guidance and information and requirements that you'll have to keep in mind in terms of how to bring people back safely. So, the city and county where you have operations, most of them in California have their own orders about the safety requirements and what you're allowed to do. The state of California has its own requirements. We've got the federal OSHA and we've got Cal OSHA as well. And then, of course, the Centers for Disease Control and Prevention are continuing to put out guidance for employers about workplace safety. So keep in mind, we've got a lot of different sources of information. Sometimes they're all in harmony and sometimes they're in conflict. So it's important to make sure that you're reviewing everything that covers you and keeping an eye on all of those requirements. For Cal OSHA, keep in mind that for most employers in California, you'll have to update your injury and illness prevention program to address issues related to COVID-19. So as you probably know, all California employers are required to establish an IIPP to protect employees from hazards, and that would include infectious disease. Cal OSHA has indicated on its website that most California employers are going to have to change and update their IIPPs to include specific provisions related to COVID-19. So this is what's come from the Cal OSHA website in terms of what your IIPP should address. You should be encouraging sick employees to stay home. If you have any employees that are reporting to work with symptoms, you need to be sending them home immediately. Cal OSHA is encouraging employers to provide paid sick leave or expanded family and medical leave for COVID-19 related reasons. Any employees that are returning to work after recovering from COVID need to immediately report to the employer a recurrence of symptoms. Employees should be encouraged to telework wherever possible. Any employees that are coming into a physical work site need to practice physical distancing and they need to wear cloth face coverings. Employers should avoid shared workspaces. So for any employer that adopted kind of an open floor plan or has kind of a layout where there aren't really barriers between work areas, that's something that you'll have to address before employees can come back. There are updated cleaning and disinfecting requirements for employers, and Cal OSHA says that all employers should discourage travel. Cal OSHA has also issued industry-specific guidance for employers. So if you fall under any of these categories, you'll need to review the specific guidelines for your industry in order to safely reopen. In addition, any employer that has operations in the city and county of San Francisco is required to prepare, post, and follow a social distancing protocol at every active facility. And the city of San Francisco has issued requirements for that protocol, which includes ensuring employees stay home if they're sick, measures to prevent unnecessary contact between employees. So making sure that people are adhering to the 6 feet of physical distancing, that work areas are separated by at least 6 feet. If you have areas where customers wait in line, you actually need to mark on the line area 6 feet apart, so the customers, kind of stand in designated spots and maintain the 6 feet of physical distancing. If you have a cashier system or a payment system, you're encouraged to use a contactless system. If you have one that requires high touch, you'll need to sanitize it pretty frequently, as well as putting in place physical barriers within the worksite. In addition, the city of San Francisco is requiring additional sanitizing measures. So, frequently disinfecting high touch areas, doorknobs, faucets, things like that people are touching a lot. Also, you'll need to provide disinfecting wipes and hand sanitizer. And then again, the city of San Francisco has other industry-specific directives depending on what industry you're in. And these are the specific industries where they have additional guidance. So if you fall within one of these industries, or if a particular portion of your business falls under one of these industries, then you'll need to review those guidelines. So in general, what we're advising for all employers is to, really think about coming out with new temporary policies and protocols regarding all of the following. There's a lot of different things that you need to think about. So for example, common areas. If you have conference rooms, kitchens, dining areas, what are going to be the rules for employees if they're going to use those common areas? Obviously the guidance would be they need to wear cloth face coverings, you need to adhere to social distancing, all those kinds of things. Social distancing, physical distancing, you'll need to continue to be vigilant about that, encouraging employees, to stay away from each other at least 6 feet apart. In-person meetings, the guidance is really not to have in-person meetings wherever possible. So even if you have people kind of coming back to a facility, if possible, limit the amount of time that people are spending in close, confined areas as much as possible. Elevators and stairwells are one of the more challenging issues to address, especially if you're working in a high-rise building where, people really don't have the option to take the stairs all the way to the top. It just becomes very difficult to maintain social distancing and physical distancing in the elevator. You could encourage people to only stay in the corners. You could have, maximum capacity in the elevator of 1 or 2 people. And you'll have to frequently disinfect the buttons to make sure that people aren't all touching the same surfaces. Again, with respect to open office space, the modern trend in a lot of offices has been to have an open floor plan where people don't have individual private offices, but the desks are all kind of next to each other. That's really going to be an issue for the time being. So we'll have to think about, if you have something like that, maybe putting up cubicles or barriers, temporary barriers, or having your workforce return in waves, maybe having half of the people or more work from home and half of the people come in, just so you can observe the 6 feet of distance. Personal protective equipment, for the most part, that just refers to the cloth face coverings. But depending on the industry that you're in, additional equipment might be required. So you'll have to check that industry-specific guidance. Obviously maintaining a maximum capacity for certain areas within the office. And then again, really minimizing work-related travel, discouraging it. And, if it is something that's really necessary as part of your operations, putting in place some very detailed guidelines about how employees can safely travel. The CDC has updated its guidance as the pandemic has progressed. So it used to be that any worker that was exposed to COVID-19 was supposed to isolate at home for 14 days. Now, any worker that is essential can continue working as long as they have no symptoms, but you have to put in place these additional measures. So you'll have to take employees' temperatures and make sure they don't have any symptoms before they start working. They need to wear a face mask for 14 days, maintain social distancing, submit to a daily temperature check, sending employees with symptoms home, all these kinds of things. So, keep in mind the CDC guidance is continuing to evolve. It's something you'll have to kind of stay on top of as the situation progresses. But as of now, this is the best guidance that's out there from the CDC. And again, kind of consistent with some of the other guidance we've already reviewed, you'll want to eliminate shared equipment to the extent possible. If you have an employee that's been exposed, you'll have to compile information on the people that had contact with that person during the time they had symptoms, as well as 2 days before when they had symptoms. We'll get into kind of the notification procedure in a bit. And then anyone that was at the facility in close contact or, within 6 feet of the person while they had the symptoms and 2 days before the symptoms would be considered exposed to COVID-19. So they'll have to kind of follow the steps that we just covered in the previous slide. So again, monitoring for symptoms, wearing a face mask, etc. Okay, so keep in mind that failing to follow these safety guidelines and failing to, put in place proper safety protocols related to COVID-19 can lead to liability for the employer. The first and most obvious is workers' compensation. So if you have an employee that gets sick at work or was exposed at work, they're likely going to have a workers' compensation claim that would cover, all of the treatment and the medical care that they need arising out of the illness. There was some new guidance that came out from the state of California within the last several weeks stating that if you have an employee that gets sick at work, there's a presumption that they got it at work and that they are entitled to workers' compensation. The employer then has the burden to try to rebut that presumption. So, some evidence that you might be able to use would be, showing that no one else at the facility had COVID-19, that you were following all these measures, that you were taking people's temperature and nobody else seemed to have symptoms, etc. But keep in mind that if you do have an employee that gets sick, there is a presumption that they're entitled to workers' compensation. OSHA enforcement actions, that would be if you were kind of failing to follow the OSHA guidance about how to keep the workforce safe from COVID-19. It doesn't seem like it's going to be targeted at employers that are mostly doing all the right things and maybe missing one or two. I think we'll probably see enforcement actions only against employers that have a large outbreak or a lot of people that are getting sick and don't seem to be following any of the guidance. But that remains to be seen. And then in terms of kind of civil liability from the employees, it's not entirely clear yet what claims might be viable. But, what we're seeing certainly in terms of what the plaintiffs bar is suggesting and kind of advertising for clients about, if you have employees that are raising concerns about safety at the work site or, raising concerns that they don't feel that it's safe to return to work, and then they're fired or, experience some kind of adverse action for that, they may have a whistleblower retaliation claim, which, as you probably all know, can lead to substantial damages, including lost wages, emotional distress, and attorney's fees. They may also have a claim for wrongful termination in violation of public policy. So we've seen lawsuits already filed in other states where employees are alleging wrongful termination for refusing to come back to work when the employer asks them to come back, raising questions about having a lack of gloves or not having enough masks, or, raising concerns about other employees that seem to have symptoms and were coming into work. So, it has kind of yet to be seen how the courts will deal with those types of cases, but we know that they're already being filed. And then lastly, we've heard some plaintiffs' attorneys claiming that employees may be able to bring a constructive discharge claim. If the work environment was so unsafe or the employer was refusing to follow safety protocols and the employee felt that they had no choice other than to quit because of that, they may try to pursue a claim of, okay, even though you didn't terminate me, you constructively terminated me because you made the working conditions so unbearable that I couldn't return to work. So again, time will tell whether that's a viable theory, but we know that plaintiffs' attorneys are certainly out there saying that it is. So the big question that we're seeing from all the employers we're working with right now is how to deal with employees who don't want to return to work. So let's say you've determined that you're in an essential business, that the work that these employees would be doing is permitted under all the orders, you're following all of the safety protocols, and you really need employees to come back, and you've got employees that are saying that they don't want to come back, they don't feel comfortable, etc. What are the options that you would need to take? First, what all of the guidance has been from all of the relevant authorities is to allow employees to telework when possible. So you'll really have to do a determination of whether that employee could do their work remotely or whether they really need to be in the office. So that's kind of the first step. If they're able to work remotely, you should encourage that and allow that as long as possible. Second, it's possible that the employee could be entitled to an accommodation. So if the employee is stating that they don't want to come back because they have a disability or some kind of an underlying medical condition that makes them more susceptible to COVID-19 or more at risk, they may be entitled to some kind of a reasonable accommodation, allowing them to either work from home or take a leave of absence from the workplace until it's safer for them to come back, until a doctor says they can come back. The leave of absence would be unpaid, so that would just be leave as an accommodation. Next, you would consider whether the employee is eligible for any form of paid sick leave or the Families First Coronavirus Response Act leave, which we'll cover a little bit later. They may have a qualifying reason for that. Typically, those leaves don't cover someone who just doesn't want to come back. Usually there has to be some kind of underlying reason or other specific purpose for them to be taking the leave. And then, note that the employees, even if they're refusing to return to work, may still be eligible for unemployment benefits from the state. So the state has put out guidance stating that, even if the employer is offering work and trying to bring them back, if the employee doesn't feel comfortable, there's a possibility that they could still get those benefits. And the guidance is that if the employee is over 65, if the job is not in an essential sector, or has not met the reopening requirements, or if the employee has kind of a weakened immune system or a chronic health condition, they still may be able to get unemployment benefits from the state. But keep in mind that when the employee applies for those benefits, the employer has to notify the EDD that the employee was offered work and they turned it down. Okay, so for those of you who have employees that are still working remotely, a few things to keep in mind. The wage and hour issues. If you have exempt employees who are paid a salary, they have to be paid their full salary for any week in which they're performing work. So, sometimes employers are tempted to say, well, you only really worked half-time last week, so we're going to cut your salary in half. That's not really how it works. They have to be paid, their full salary for any week in which they do any amount of work. If you have non-exempt hourly employees, they only have to be paid for the time that they actually worked. But keep in mind that the meal and rest break requirements for hourly employees still apply, even though they're working from home. So, obviously it's a little tougher to enforce those requirements, make sure that people are taking timely breaks. But, it's important to remind the hourly workers that they still are expected to take those breaks. And if they feel like they're not able to do it, they should consult with the employer about why that might be. Expense reimbursement. If you have employees that are working remotely and there's certain equipment or internet or phone service that they need in order to do their job, for the most part, the employer is going to be required to cover at least a portion of that. So, a few years ago, there were a lot of cases around cell phone reimbursement where employees were required to have a personal cell phone that they sometimes used for work and sometimes used for personal purposes. Even if the employee is still using that cell phone for their personal purposes, if they're using it at all for work, then the employer has to reimburse at least a portion of the bill. I think as more and more employees are working from home and kind of using their home internet to do their work, we're going to see the same issue coming up with respect to home internet. So just keep that in mind. Workers' compensation can be tricky when people are working remotely. If they get injured in their home while they're working, there may be an argument that they're entitled to workers' compensation. More commonly, what we're seeing is people are getting kind of ergonomic injuries from not having the proper ergonomic setup for their workstation. So maybe they're getting wrist pain, back pain, etc. In that instance, that's probably a good argument that they're entitled to workers' compensation. So you might want to be checking in with employees to make sure that they have the setup that they need at home to work comfortably without getting injured. With respect to reasonable accommodations, if you have an employee with disabilities who needed an accommodation at work, maybe some kind of a special chair, some kind of an ergonomic desk, something like that, the DFVH guidance has been that the employer should still provide the accommodation at home unless it would be an undue hardship on the employer. So again, now if you're foreseeing that you're going to have a lot of employees working from home for a while, it might be a good time to check in with them, make sure they have everything they need to work safely and comfortably. Okay, furloughs and layoffs, as I mentioned at the beginning, hopefully this is something that's kind of in the rearview mirror for most employers. Keep in mind, you probably heard back at the outset of the pandemic that Governor Newsom relaxed the WARN Act requirements, which relate to mass layoffs in the state of California. So, previously employers were required to give 60 days notice for any layoff that affected 50 or more employees, or if you had a plant that was closing. Now, given the pandemic and kind of the abrupt economic changes that have happened for most employers, you're only required to give as much notice as is practicable, but the notice has to include an explanation of why they're not able to give the full 60 days of notice. So for most employers, it would really just be a statement that, due to the COVID-19 pandemic, there were unforeseen economic conditions, and that's what's leading to the layoffs. Another issue that is not commonly known, but something to keep in mind is that if you're going to be furloughing an employee for longer than 10 days, it's probably required that you pay out their accrued PTO. So, any furlough that lasts longer than 10 days is almost similar to a termination. And so the labor commissioner has said in that instance, the employees would be entitled to the value of the accrued PTO they had. What we've been advising is you could give employees the option of whether they want the cash out of the PTO at that time or whether they want to maintain their PTO for the future. But you want to make sure that if you do give them that option, it's in writing. You have the employee submit what their choice is in writing, just so you have a record that there was an option and the employee elected not to take it. Finally, reporting time pay. This is probably not as relevant right now, but if your business was not allowed to open because the local government was saying that you couldn't open, you wouldn't have been required to pay reporting time pay for those employees. Normally, you'd be required to pay them for up to half of their scheduled shift. If you're considering layoffs and you're not sure about it, keep in mind that the EDD has a work share program where if you're able to keep employees at least working part-time, maybe a few hours or 10 or 15 hours a week, they can still be eligible for benefits from the state to offset the lost income, and it's a nice alternative to laying people off. The employees can earn through the work share program more than the typical $450 cap on unemployment benefits. So, whatever you're paying them, plus they could be eligible for more from the state. They could also be eligible for the additional, I think it's $600 that the federal government is currently providing for people who are on unemployment. If you're interested in participating in the program, it requires you to submit a work share plan to the EDD. So that's something you can check out on the website for the EDD. And participating in the work share program may also be helpful for those of you who took the payroll protection loans from the government. It may help with the forgiveness aspect because you won't be laying off the employees, you'll be keeping them on the payroll. So keep that in mind as well. Okay, employee privacy and medical issues. Obviously, a lot of unique and kind of novel questions that have been coming up in light of the COVID-19 pandemic, in particular, trying to return people to work safely. The EEOC and the DFEH have issued guidance basically allowing employers to do a lot of things that they normally would be unable to do. So employers are allowed to ask employees whether they're exhibiting any symptoms of COVID-19. You can take employees' temperatures to see if they have a fever. If you have employees that are calling out from work, you can ask them specifically why they're absent. And if you have employees that have missed work or been out of work, or even just working from home, you can require a medical note stating that they're safe to return to the office. One thing to keep in mind is that the EEOC guidance has said that with respect to medical notes, if you're thinking of requiring employees to bring in a medical note stating that they're safe to return to work or that they don't have COVID-19, just keep in mind that it's probably going to be very difficult for employees to get in to make a non-emergency appointment to see a doctor right now and get that kind of documentation. So you may not be able to get it in kind of a timely manner. So the EEOC guidance has been that employers should rely on their judgment as well as recommendations from health professionals about whether you should really be requiring medical documentation for people to come back. They've also suggested kind of waiving that documentation requirement, keeping in mind that it may be difficult for people to get the documentation. However, adding to the complication of the issue, if you are eventually planning to seek the tax credits for the new coronavirus leave that was required by the federal government, you may actually need the documentation to prove that the employee had a valid reason for taking that leave. So, a lot of different factors to consider when you're thinking about what kind of medical documentation you might be asking for. So if you are going to require your employees to undergo COVID-19 testing, which you are authorized to do under the EEOC guidance, keep in mind that mandatory medical testing must be job-related and consistent with business necessity. So I think if you're having people come back to a work site where they're going to be encountering other people, they're going to be around other people, you'll probably have an easier time showing that need. If everybody's teleworking and you just want all of your employees to get tested, you're probably not going to be able to show that you really needed to make them undergo that testing. If you are going to require COVID-19 testing from your employees, you have to ensure that the tests are accurate and reliable. As you've probably seen in the news, there's a lot of new tests that are coming out almost on a weekly or bi-weekly basis. And it's not clear yet which ones are the most reliable or accurate. So the EEOC has suggested that employers rely on the FDA and CDC guidance about which tests are currently kind of the best practice in the field. Keep in mind that there is a distinction between testing for a current COVID-19 diagnosis and testing for antibodies. So if you're going to be testing to see whether somebody has COVID-19 right now, that would be a test that would be determining whether that person is safe to come to work, and that would be permissible. But if you're going to be testing for antibodies, that's not really something that's going to show you whether someone is safe to be in the workplace at the moment, and in fact would be considered probably an unlawful inquiry into somebody's medical history. So you should avoid the antibody testing if you're going to be asking your employees to undergo testing before they come back. If you do receive notification that someone in your workforce has tested positive and you believe that others in your workforce have been exposed to that person, you should notify them of the exposure, but you have to keep in mind that you cannot reveal the name of the person who has tested positive because that's confidential information. So the DFEH in California has actually given us kind of some template language to use if you're notifying people of exposure. It's here in the slide. It's also in the DFEH guidance, but you'll get these materials after the presentation and you'll have it. Another kind of hot topic that's been coming up lately are the contact tracing apps that people are using to sort of determine who they may have come into contact with and whether any of those people have tested positive for COVID-19. I think a lot of employers are weighing whether to roll something like this out for their workforce. And so just some considerations to keep in mind. First, think about carefully how you'll communicate the app to the employees. I think a lot of employees can be suspicious if an employer is asking them to download a new app onto their phone, particularly if their phone is used for personal and work purposes. So just be very careful about how it's communicated and make sure that you're very careful about explaining the purpose of it and what data will be collected and why. If you are going to use contact tracing apps, our advice is to make it a voluntary process versus mandatory. You'd probably want to get consent from employees. As I think most of you know, most of the apps that we have on our phones, they serve one primary purpose, but they may also be collecting other kinds of data that we're not even thinking about. Information about contacts, information about other things that people are doing on their phones. And so you don't want to be in a situation where it looks like you're basically requiring your employees to turn over a bunch of private information from their phones to you. For any employer that has a unionized workforce, keep in mind that a contact tracing app is something that you'll probably have to bargain with the union about. You wouldn't be able to just unilaterally roll that out. And then keep in mind the privacy concerns about the data that you're collecting. So, any information that you collect from employees about COVID-19, their activities related to COVID-19, their potential exposure to COVID-19 is all a confidential medical record and has to be kept in a manner that restricts access only to certain people and is kept confidential. If you're an employer that's covered by the California Consumer Privacy Act, you'll probably also have to comply with some notice requirements to the employees about the nature of the data that's being collected and how it's going to be used. And if you are considering using a contact tracing app, just make sure that you vet it pretty carefully and you have a full understanding of what is the data that's being collected through the app and where is it being stored and how is it being shared with third parties, etc. But basically our advice around these apps is it can be a positive thing, and there probably are a lot of employees that might want to use a contact tracing app for their own health and safety and their own knowledge. But the best practice is to make it an optional process. So we have a lot of employers that are kind of doing surveys of their employees about their out-of-work activities related to social distancing, compliance with the COVID-19 public health orders. Keep in mind that if you're doing that, you have to be careful not to run afoul of other privacy concerns for those employees. So make sure the questions are connected to compliance with the relevant public health orders. You'll want to limit any questions about protected classifications as much as possible. So instead of asking employees, have you attended church in person, which could raise some other protected issues and privacy issues with respect to those employees, you'd want to ask them, have you attended any large group gatherings of more than 5 or 10 people? Similarly, you'd want to avoid implicating the privacy interests of third parties. So if you're going to be asking about what members of your employees' households have been doing, you'll want to be careful about not asking about whether their family members have gone to church or things like that. You want to try to keep it as narrowly tailored as possible. So this is just a sample employee survey. If you do have employees that are returning to the office, returning to work, you'll probably want them to certify before they go in there that they meet all of these criteria. And these are sourced from the Cal-OSHA checklist for workplaces. So you'll be asking the employee to certify that they've taken their temperature and they don't have a fever, that they don't have any new and otherwise unexplained symptoms in the last 24 hours. The reason why we use the word unexplained is because some of the symptoms of COVID-19 are also symptoms of allergies, and you don't want to be excluding people from the workplace, who just have allergies or something that's not actually going to be a safety risk to other employees. You'll want them to certify that they're not currently required to quarantine and to agree that they'll wear a cloth face covering at all times while they're in the building. This is the checklist that came from the city of San Francisco. you'll need to provide this checklist for all employees that are working in the city of San Francisco outside of their homes. And you can find this at the link. We copied the URL onto the slide. Okay, and lastly, just some reminders about medical records. Again, any information that you're collecting from employees about COVID-19, whether it's a survey about their exposure to it, a checklist that you're asking them to fill out that they don't have any symptoms, if you're issuing a COVID-19 test or taking their temperature, these are all confidential medical records. And in the state of California, those records have to be stored separately from employees' personnel files. So it can't just go in the main file where you keep all of their other personnel records. It has to be separate. The access to those records has to be limited. So, we always recommend if you're storing them electronically, password protection, maybe only somebody in HR would have access to it, or, one or two people on a need-to-know basis, but should not be something that other employees would be able to get into. And then finally, these are the types of examples of things that would be considered medical information that have to stay confidential. So any statement from the employee that they have the disease, that they suspect they have the disease, or any notes from questioning employees about their symptoms or their activities. Okay, so complying with EEO obligations. We've had a lot of confusion from people about whether the EEO laws remain in full force and effect now that we're dealing with a pandemic. And the answer is that they do. So the things that you were already obligated to do, keep in mind that you're still obligated to do them. And the EEOC and the DFEH have been putting out lots of guidance about how to navigate the pandemic within the boundaries of those laws. So first, as we all have seen in the news, the pandemic has resulted in an increase in anti-Asian bias, anti-Asian rhetoric. So the EEOC has issued guidance recommending that employers, both remind managers that they have an obligation to report and address discrimination and harassment, and to remind workers that discrimination and harassment will not be tolerated. So, this could be in the context if you're about to have people coming back to work, you could just send out kind of a reminder and just make sure that people are staying vigilant and reporting anything that they suspect violates your anti-discrimination, anti-harassment policy. Disability-related obligations, we covered this briefly in the teleworking section, but employees that have underlying medical conditions may be entitled to reasonable accommodations like telecommuting or a leave of absence. Interestingly, the EEOC guidance has called out, in addition to physical disabilities, mental health disabilities that may be interfering with employees' ability to work at this time. And specifically that if you have an employee with an underlying mental health disability, or maybe one that hasn't been previously disclosed, but now may be having some challenges, those employees may also be entitled to reasonable accommodations if they're experiencing, increased anxiety, stress, trauma, anything like that related to the pandemic. So keep that in mind as well. But as with all disabilities, typically you'd require a medical note from a doctor explaining what accommodation the person might need. Complications from COVID-19 may also be considered a disability, depending on the severity. So keep in mind that if an employee has COVID-19 or had it and has recovered but is still experiencing some challenges, there may be an accommodation that's needed there as well. The employers cannot require their employees to disclose the existence of a compromised immune system, because that's probably going to disclose a disability, which, as you know, you're not permitted to require employees to disclose. And then, as we discussed earlier, if you are terminating employees for not coming to work in compliance with government directives, that could give rise to a wrongful termination claim. As you're bringing employees back to work, there are some additional EEO issues that you should be aware of. The first one is to ensure that your hiring and return to work decisions are not being influenced by protected categories. So you couldn't make a unilateral decision to say anyone over 65 is not going to return at this time, anyone under 65 can return, or anyone that is not disabled can return, but anyone who is disabled has to stay out. The employer is not permitted to make unilateral decisions of that nature. You can require that applicants take a COVID-19 test before they start working. So if you've issued somebody a conditional employment offer, you can require them to be tested for COVID-19. If they come back with a positive diagnosis, you can either revoke the offer if you need them to start immediately, or you can delay their start date. But keep in mind that if you're planning to revoke the offer, you'll probably need to show that you really needed them to start immediately and there was no reasonable way to delay the start date. If you have at-risk individuals in your workforce, so anyone with an underlying disability, someone who's pregnant, someone who's over 65, again, the employer cannot unilaterally delay them coming back, but you can ask the employee if they're comfortable returning or whether they would like to kind of delay their start and return date. And we've seen pretty frequently that it's often those employees who are kind of volunteering, like, I'll come back in a later wave of employees. Somebody else can come back now, but I'd like to stay home. So just important to kind of have a dialogue with the employees, make sure that they're part of the decision. The most recent EEOC guidance has acknowledged that for employees with disabilities, employers may have an easier time showing undue hardship in providing accommodations due to the COVID-19 pandemic. So as you probably know, under federal and state law, employers have an obligation to make reasonable accommodations for employees with disabilities unless they can show that the accommodation is an undue hardship. And basically now we have an acknowledgement from the EEOC saying that because of the COVID-19 pandemic, there may be additional factors that could support a finding of an undue hardship in providing an accommodation. So some of those that were specifically called out in the guidance would be logistical challenges in conducting a needs assessment, difficulty in acquiring equipment, difficulty in providing temporary accommodations or removing marginal functions from the job. And then finally, economic factors, such as a sudden loss of some or all of the employer's income stream or a reduction in discretionary funds could make it easier to prove undue hardship. Now, historically, courts have not been very sympathetic to the argument that employers can't provide an accommodation because it would be too expensive. Normally, that's not really a great argument. I think that will continue to be the case for large employers, but I think for smaller employers that may be dealing with, economic hardship of their own right now, this may provide a little bit of leeway for them if an accommodation would be unreasonable to provide. But make sure that if you are going to make a determination that you can't accommodate an employee's disability, that you check with counsel, because obviously that's a decision that creates a lot of risk of litigation. Also keep in mind that with regard to personal protective equipment, there are accommodation obligations that may require alternatives for certain employees. So for example, if you have an employee with a disability that's allergic to latex, you may be required to provide non-latex gloves. Or, if you have deaf employees, you may be required to provide modified face masks for interpreters. Or gowns for employees that are in wheelchairs. So keep in mind that just because an employee wouldn't be able to use kind of the standard personal protective equipment that you have doesn't mean that they can't return to work. You still may be obligated to look for alternatives for them. Similarly, for religious accommodations, depending on the nature of the accommodation, or if somebody has religious garb or something like that, you may also be required to provide modified equipment on that basis. The direct threat issue is another kind of interesting thing that's been coming up. So under the Americans with Disabilities Act regulations, an employer can exclude an individual from the workplace if that person is deemed to be a direct threat, which means that that person's disability or that person would pose a significant risk of substantial harm to the person or other workers in your workforce. The EEOC has cautioned that even still, this is a very high standard. So it can't just be based solely on the CDC's guidance saying that somebody with an underlying condition is at increased risk of COVID-19. It has to be more than that. So, again, the EEOC is really discouraging kind of unilateral decisions from an employer excluding people from the workplace unless there is a very substantial showing that it's not safe for them to come back. So the factors that you would need to consider in determining whether someone is a direct threat and would need to be excluded from the workplace would be the duration of the risk, the nature and the severity of the potential harm, the likelihood of the harm, and the imminence of the harm. And after you've considered all of those factors, there's an additional factor, which is that you have to demonstrate that you could not provide a reasonable accommodation that would let them come back to work. So for example, if somebody has maybe a very serious underlying health condition where you're concerned that they would come back and maybe be at risk of contracting the disease or something like that, you wouldn't be able to just decide on your own that they can't return to the workforce. You would also have to demonstrate that there was no accommodation that would allow them to come back. And so perhaps that would be there's no private place where they could work that would keep them away from others. There's no procedures that could be put in place to minimize their exposure. There's no protective equipment that could be given to them to help, reduce the risks. So just keep in mind it's a high standard. If you're considering doing this, it's something that should also be done in consultation with counsel because it's likely to lead to litigation. Okay, lastly, we'll just kind of run through these quickly and leave time for questions. Time off options for employees. There are a lot of potential sources of time off for employees right now. Accrued PTO, accrued paid sick leave. There's the new federal leave, which we'll cover. There's also unpaid options. So if you're offering a leave of absence as an accommodation, or you're offering a personal leave of absence for someone that doesn't want to return, or if someone is eligible for FMLA or CFRA leave. And then finally, there's other types of time off that might trigger supplemental income from the state. So some employees might be entitled to state disability or unemployment benefits, or California paid family leave. One issue that's come up kind of lately that may have flown under the radar, for those of you who have unlimited PTO policies, there was a case that came out in the beginning of April where an employer basically had their unlimited PTO policy almost invalidated, and the court determined that they were required to pay out accrued PTO in some amount that the court determined because there were these factors that the court decided needed to be present in an unlimited PTO policy that the employer didn't have. So if you do have an unlimited PTO policy for your employees, you'll want to review it to make sure that it satisfies all of these criteria that were addressed in that California Court of Appeal decision. It needs to be in writing. It needs to say that the PTO is not additional wages, but is part of an employer providing flexibility. It would have to spell out the specific rights, obligations, and consequences of related to the unlimited PTO. It has to allow sufficient opportunity to take time off, and it has to be administered fairly. In keeping with that, if you do have an unlimited PTO policy that you're already reviewing for compliance with these requirements, you'll probably also want to think about how your unlimited PTO policy interacts with employees who are refusing to return to work due to COVID. So we have had a few clients raise this concern where they say employees are saying they don't want to return to work because they don't feel comfortable or they don't feel safe. And because the employer has an unlimited PTO policy, they just kind of want to stay out on leave and get paid indefinitely, which is something that you'll probably want to address in updating the policy. As most of you all probably know, the federal government passed the Families First Coronavirus Response Act a couple months ago, which applies to employers with less than 500 employees and requires 2 new categories of paid leave for workers for reasons related to COVID-19. Keep in mind that this leave is effective all the way through December 31st. So as you're bringing people back to work, there still may be employees that are experiencing a qualifying reason for that leave. The law provides refundable tax credits to cover the cost of providing the leave, and the tax credits can be advanced to employers. You know, given the kind of issues that we know of with cannabis employers and the federal government, specifically that cannabis employers are typically not eligible for certain tax credits and tax benefits, we aren't yet sure whether these tax credits will be available to cannabis companies. We certainly haven't seen anything saying that they're not, and we think there are some good arguments that they are, but it's something that you should consult with tax counsel about, just to make sure you're covering your bases. The two components of the new federal leave, there's emergency paid sick leave, which is 80 hours of paid sick leave at the employee's regular rate. And it covers the following reasons. So the employee would have to be unable to work or to telework because they're quarantining or isolating based on doctor or governmental orders. They're experiencing COVID-19 symptoms and seeking a diagnosis. They're caring for someone who is subject to a quarantine or isolation order, or they're caring for a child whose school or place of care is closed. And there are these kind of payment caps under the law. So if an employee is paid regularly more than this amount, this is the only amount that they would be eligible for under the leave. The emergency paid FMLA leave provides 12 weeks of job protected FMLA leave to care for a child whose school or place of care is closed for COVID-19 related reasons. And that's the only reason for this leave. So this leave would not be available to someone who is personally sick or personally experiencing symptoms, or to care for someone who's experiencing symptoms. It's only for people who are caring for a child whose school or place of care is closed. The first 2 weeks of this 12 weeks are unpaid, but the employee can use their PTO or paid sick leave. And then the remaining 10 weeks are paid at 2/3 of the employee's pay, up to $200 a day. There are some hardship exemptions for these leaves. So if you have less than 50 employees and you're seeking a hardship exemption, right now the DOL guidance is to internally document why you can't provide the leave and why it would jeopardize the viability of the business. Both types of leave can be taken intermittently, so the person doesn't have to be out for 2 straight weeks or 12 straight weeks. They can take a little bit here and a little bit there, as long as the employer's policies allow it. And the DOL is encouraging employers to allow it. Employees who have been furloughed, who don't have any work to do, are not entitled to the paid leave. So it's only employees who would have work, would be able to do work, but for these qualifying reasons. And the new paid leave is also in addition to any leave that's already provided by the employer. So if you're providing paid sick leave, PTO, other types of leave, this is on top of that. Just quickly, there's been kind of a relaxing of the requirements for disability benefits. So if you have employees that are experiencing a disability and unable to work because of COVID-19, you should encourage them to contact the Employment Development Department about their eligibility. California paid family leave provides partial wage replacement benefits for employees who are caring for a family member. So if you have an employee who has a family member that is sick with COVID-19 or another medical condition, they might be eligible for these benefits that are administered by the state. So again, they would apply to the EDD for those benefits. Keep in mind that paid family leave does not provide job protection. It only provides the wage replacement. So the job protection would be provided by another statute potentially if the employee was eligible. Lastly, these paid sick leave ordinances, Los Angeles and San Francisco have both passed ordinances requiring additional paid sick leave for employees who are unable to work due to COVID-19 related reasons. And under both of these ordinances, the employer cannot require a doctor's note in order to authorize the leave. These are some additional websites with guidance for employers. When you get the materials, these will all be in there, but some things you might want to check out. And then lastly, we have a couple of minutes for questions if anyone has any.